With the engagement of Taylor Swift and Travis Kelce, there's been a lot of talk on social media about prenuptial agreements. But what many people don't know is that these agreements, as well as their lesser known cousins, postnuptial agreements, are not just for the very rich. Others can benefit from them as well. That's why in this episode of the podcast, I talked with New Jersey certified family law attorney AllynMarie Smedley about how these two agreements work, when they're appropriate, and how they can help couples both before and after they get married. My guest today is AllynMarie Smedley, the founder of Smedley Law Group here in Woodbury, New Jersey. And she is a certified matrimonial law attorney, concentrating her practice solely on family law matters, including divorce, pre- and post-marital agreements, support and alimony, child support and custody, college contribution matters, grandparent visitation, paternity determinations, parenting time, domestic violence, and adoptions. Let's face it, if it's family law, she does it. So welcome to the show, Allie.
Thank you, Steve.
And we're here today to talk about pre- and post-nuptial agreements, because oftentimes the issues that they cover can seriously impact your financial planning and your financial future and financial freedom. And we're going to talk about how these two documents can be used strategically, and hopefully there isn't a divorce or a problem, but it's strategic planning, just like everything else. So I guess the first question is, there's something called a prenuptial agreement and a postnuptial agreement. So can you tell us briefly what each one is and the differences?
So, prenuptial agreement is an agreement that is reached between prospective spouses before they have actually married.
Mm-hmm.
It is governed by statutory law in New
Mm-hmm.
Jersey. And in addition, case law governs it as well, but it's primarily governed by statute. A
Mm-hmm.
postnuptial agreement, or what could be called a mid-marriage agreement, is one that is entered into after the parties have already gotten married.
Mm-hmm.
Prenups are more widely enforced, I would say,
Mm-hmm.
because of that statutory interpretation.
Mm-hmm.
And there's a very strict set of rules of what a prenup needs to have and what it needs to look like when it's executed. Postnups are only governed by case law. There's no statutory provision that governs them. Courts are leery of postnuptial agreements because in a prenup, if you don't like what's going on, you can just walk away. You
Mm-hmm.
don't have to get married. You can abandon the wedding. You can move on with your life. In
Mm-hmm.
a postnup, you're already married. You might have had kids. You might have given up a career. So there's all of these other factors that a court can look at to say, that person doesn't have the same ability to walk away that someone with a prenup would.
Right. And now when you say between statute and case law, just for our listeners, case law is when a court gets involved, and when a postnuptial agreement is challenged on its enforceability, and the judges then make a decision on that.
Yep, that's perfect.
Okay.
And the other concern with postnups is that there's a view that they're inherently coercive,
Mm-hmm.
right? So if you have a couple who's having marital problems, you have one person who presumably wants to stay in the relationship and one person who wants to leave it.
Mm-hmm.
And that creates this imbalance of power between the parties and creates a coercive situation. So
Mm-hmm.
courts look at postnups with a much higher level of scrutiny than
Mm-hmm.
they look at prenuptial agreements.
Now, are postnuptial agreements often discussed or entered into, when everything's okay, the marriage is fine, and they just want to enter into this agreement, or does it more often come up with strained relationships where maybe they're separated and contemplating divorce, and they decide to have this agreement?
I would say it's fair to say it comes up in both situations.
Mm-hmm.
One of the leading cases on mid-marriage or postnuptial agreements was a couple who had started working on it before they got married, and then a year later, husband started saying to wife, like, I want to have this agreement, I want to do it. And she was resisting, and she finally gave in because she felt like he wasn't going to let up. But
Mm-hmm.
one of the factors in that case that the court really heavily relied on was she had just given birth 3 weeks prior to their first child.
Ah.
So she was pregnant during the negotiations. She signed it 3 weeks after the kid was born. She was doing like round the clock breastfeeding. She was exhausted, sleep deprived. And so the court looked at like all of those factors and said, even though it really, they were trying to get the prenup done just post-nuptially, all of those factors created this level of coercion that the court wasn't comfortable with. And they found for those reasons that the agreement itself was somewhat unconscionable, but her mental state going into it played a lot into their decision to vacate it. Or I'm sorry, to remand it to make sure to have the trial court make a determination if it was going to be vacated or not.
Okay. All right.
But
So
and the other ones are marriages breaking up. Somebody says, I want to leave. And the other one says, well, I don't want you to leave. I want you to stay. And they're like, okay, well then sign this agreement. So there's that level of coercion again.
Right.
That comes in.
Okay. All right. Well, let's go back to the prenuptial agreement. So we have this couple, they're engaged, they want to get married. And I guess the question is, do you need one? If you were advising them, what would you tell engaged couples as to when having a prenup is a good idea and where it may not be necessary?
I think prenups are good for anybody, honestly. I think there's a preconception that they are for people who have means, who have wealth, who have a lot of assets, and they don't have to be limited to just those types of financial situations. What a prenup does is it basically sets the stage in the event a marriage breaks apart. So you can predetermine, alimony, asset distribution, commingling of exempt assets. You can determine all of the outcomes except for custody and child support. Those are the two things you can't contract away in a prenup, but you can lay the foundation for the remainder of essentially the equitable distribution portion of the agreement, as well as the spousal support portion, and have that already done. So if the marriage falls apart, you're not dealing with this massive litigation. You're dealing with, if you have kids, a couple narrow issues. So basically you are giving yourself, you're taking control of yourself and your life and taking it away from the judge by saying, if this marriage ends, this is how it's going to go. And so I think anybody who gets married can benefit from kind of taking control of your own destiny, right? Like, if you leave it up to chance, you might not like the outcome the court comes up with.
Right.
So that's why I think that they're really important for anybody, regardless of the means of the couple involved.
Right. Well, just for our listeners too, you mentioned the two exceptions to a prenuptial agreement, which is child support and custody. Just so the listeners understand. And by the way, we're talking about here in New Jersey.
Yes.
So anybody outside the bounds of New Jersey, this is an interesting topic, but you should talk to an attorney in your state. And of course, talk to an attorney anyway about it, since we're not giving legal advice here. But the child support, it's essentially a table, a calculation, right? They look up relative incomes and certain factors on a table, and they come up with a child support amount.
Correct.
Right?
That's what they do. But what some people have tried to do in the past with prenups is contract away child support.
Right.
And that's against public policy in the state. A parent cannot contract away the child's right to support. So if somebody tried to do that in a prenuptial agreement or even a marital settlement agreement, that clause would be vacated if it was raised before the court. So, and because custody ties into child support with parenting time, that's why they're just both against public policy to contract away those issues, because custody is determined by the best interest of the child who's not party to the contract.
That's what I was about to say. Yeah, it is tied into the child support, but I think that here you have this child who wasn't around even before the parents were married, and now you're trying to make these decisions which may not be in the best interest of the child, and that has to be determined independently.
Correct.
So, all right. So that's really, so I guess what you're saying is anybody that is getting married should at least consider having a prenuptial agreement. You don't have to be, Taylor Swift and Travis Kelce, who are, as we said, discussed before I hit record, are definitely getting a prenup.
Oh yeah, it's going to be like this.
Right, where you're dealing with some very different financial situations and things like that, and particularly where you're in a community property state where it can make a difference, which always amazed me why Bill and Melinda Gates didn't have a prenup when they got married, and that made that divorce interesting.
Yeah.
So I guess asking your fiance for a prenup can be a bit of a relationship minefield. Do you have any advice to people as to how to handle that situation, how to bring it up and discuss it in a way that doesn't get people upset?
So the first piece of advice is don't wait until right before the wedding. People do
Okay.
that. We have gotten calls from people and we'll say, okay, well, when's the wedding? And they're like, next Saturday.
Oh,
Like you're basically baking coercion into the situation by waiting that long because what bride or what groom wants their fiance to drop this in front of them, essentially like at the rehearsal dinner, like, well, we need to sign this or we're not getting married. It's
right.
so inherently coercive. So I always tell people you need to have that conversation early
Hmm.
because one, there might be some resistance.
Hmm.
And two, you want to eliminate any appearance of
Hmm.
coercion. That's
Right.
really important. And optically, if the closer you get to the wedding, the worse it looks. In
Hmm.
terms of approaching it, I think if you come at it from the standpoint of we're taking control in the event this doesn't work. We're
Hmm.
determining what the outcome is. We're determining what the rights to, spousal support are, the rights to assets are.
Hmm.
It's a money saver. Contested divorces are really expensive. They
Hmm.
can drag out for a year, 2 years, if the parties don't agree. So my view is if you can kind of sell it in a sense of, we're trying to make future us have an easier go of it if the marriage doesn't work. And
Hmm.
so we're not spending all of our money on attorneys and litigation. A really well-crafted prenuptial agreement can kind of eliminate that.
Hmm. Well, isn't there? I mean, certainly that's the economic answer, and certainly one of the big reasons why this is a topic for the podcast. But it's also a highly emotionally charged issue
Yes.
where the other side can say, "What? You don't think this is going to work? You're wondering even before we're married whether this marriage is going to work, and you're trying to manage the downside. That can have a very emotional uh, backlash to it, I guess."
It can, and people I think are right to initially get upset, right? Like it's a thing that has a very negative connotation on it. And I think
Hmm.
the initial gut reaction is to get upset.
Hmm.
But I think if you can get somebody to understand that it's not saying that the marriage is going to fail,
Hmm.
but it deals with what happens if it does. For
Hmm.
all they know, they could meet the real love of their life 10 years down the road, and they could be the person who wants out.
Right.
You don't know. You don't know what the future holds. And it's not presumptive that the person suggesting it has already got like one foot out the door,
Hmm.
right? It's really just taking control of your life because what if it happens and that person now takes the argument, the position that there should be no spousal support, or hey, this house that we purchased, while we were dating, well, it's only in my name, so it should only be my house, and you are limited in what you're getting from it.
Hmm.
So there's definitely like advocacy points that can be raised in that situation to
Hmm.
create for yourself maybe a better outcome than you would have gotten had you gone to court.
Hmm.
Just because it's a prenuptial agreement doesn't mean that it is in one person's favor, right? The court's going to look at it and enforce it if the agreement's fair and just. So they're going to look at, is this agreement fair? Is it unconscionable? And that's what they'll look at when they go to enforce it.
And certainly get some testimony from both sides as to voluntariness.
Absolutely.
It may have the person that is not getting much out of it may have been fully all in and wanted it, and yeah, I understand, Your Honor, but this is what we want. Certainly would come into play.
Yeah, they don't do voir dire on them at the time they're executed. But the
No,
statute does require certain things
right.
that have to happen. And one of them is you either need to have an attorney sign off or an express waiver of the ability to have an attorney look at it.
Right.
You're also required to have schedules of your assets and liabilities attached.
Hmm. Well, we'll get into how we make the sausage in a minute. Uh,
Okay.
but so, because a question I have too, and there are other instances in which a prenup may be a good idea. Uh, in addition to divorce, does a prenup resolve any issues on death as far as inheritance by the surviving spouse?
It can. Parties can agree to waive their elective share. They can agree to waive any rights of inheritance under the law. And
Mm-hmm.
I've seen that. And that's more common, I think, in cases where there are a lot of assets
Mm-hmm.
at the outset. Like it comes in with, family trusts, family wealth, those
Mm-hmm.
kinds of things where there might be outside forces looking to secure or protect those assets and insulate them and keep them in the family. But they are common.
And certainly in instances, I do some estate planning with blended families.
Yes,
This may be the second marriage for one of the two of them, and they have children by the previous marriage, and they're trying to not just necessarily in a divorce situation, but in death, it can be part of basically estate planning as well, right?
absolutely.
So it would be a good idea, at least for uh, people in second marriages with children with prior marriages or things like that, or inherited wealth and et cetera, trusts, as you mentioned, to have this looked at and consider having a prenup.
Yes.
So, all right, so let's get back to making how the sausage is made. Uh, so prenuptial agreements, as you said, are controlled by statute,
Mhm.
and the statute has several requirements in order for it to be enforceable in any way in the first place. So, if the couple decide, yeah, we should have a prenup, step us through what the process is, what they need to do.
So typically we will have, you cannot represent both parties. That's the first thing. So if someone suggests, we're going to go to my lawyer,
Mm-hmm.
no, parties should have independent counsels. That's the first thing. And what I'll do is I'll talk to the client and I'll tell them, we need to create a schedule of your assets and liabilities.
Mm-hmm.
That's the first thing. And then we
Mm-hmm.
talk about, what is, if they have significant assets they're looking to protect, what do you see in terms of scenarios of either insulating or contributing those to the marriage?
Mm-hmm.
Is it, if it started out as an exempt asset, is it forever as exempt asset no matter what happens to it?
Mm-hmm.
Or if you intentionally convert it and put it in joint names, does that take away the exempt nature of it? So you kind of work out like what their goals are and what the provisions of the agreement look like
Mm-hmm.
to them.
Right. And there
Then
has
put
to be
it together.
right, full disclosure of assets by
Correct.
both sides because
Yes. Yeah. You can't you can't either not disclose or fudge the disclosure. I actually just read a case today when I was kind of brushing up for this, and what the husband did was he had his accountant massage the business values on his asset schedule,
uh-huh.
listing some of them in gross value and some of them in net value, and the court found that created like a multi-million-dollar swing
Oh man.
in the value of the assets. So the wife thought that the assets were maybe valued at 8 million and in reality they were valued at like 12 million.
Mm-hmm.
So you have to be forthcoming with what the assets and liabilities are. That can be a problem if you're looking at enforcement down the line, is if that disclosure is not done.
Right. Do you recommend having, in addition to an attorney review the documents and everything, have an accountant
I think
review
it's
the financial
fact
disclosure?
specific. I think it's fact specific.
Yeah.
The accountant would be helpful in certain instances, especially if you're getting into higher level things. Like, I have this business and it's valued at X amount of dollars. Like, how did that come up?
Right.
Is that a number somebody pulled out of the air, or is it something that was created by an accountant? And consulting with them is helpful in those
Right.
situations.
Yeah, it depends upon the size of the assets and the
Yeah.
complexity of the assets. For example, if you have one party who owns a business, then it might be a good idea to get a business valuation as
Yeah.
part of that so that the business owner is not picking a number out of the air or even in good faith mistakenly valuing it and it's worth less or more than what they honestly think it is.
Correct. Correct.
And
And
that,
and that also helps if a business is not addressed, like if they choose not to address it in the agreement down the line, if you've done that valuation, now you can show what it was worth at the time of marriage,
Right.
which can be definitely helpful in a divorce litigation.
Right, because now you have what would be called in other instances sort of a tax base. You know
Yeah, exactly.
that you're not valuing the asset at the time of the filing of the divorce complaint, which I don't do family law, but it's my understanding that basically that's sort of the bright line. You're actually doing it as of the valuation for the prenuptial agreement.
Right. And you can look at, what was the impact of, because arguments that just to do a brief aside, arguments that are made is that the non-working spouse somehow increased the value of the business through their efforts.
Right.
And so that'll help either neutralize or support that argument, depending on what side you're on,
Mm-hmm.
by having that valuation instead of having to go back in time to create it.
Mm-hmm.
Yeah, definitely advisable, I think, if there's business interests.
All right. So we have each side gets their own attorney. We have a full and accurate financial disclosure, and where necessary, on a fact basis, you might have an accountant review everything. Are there any other requirements under the statute for making this agreement?
Trying to think without actually reading the statute again. um, Specifically, I know it is the attorneys are the big one.
Mm-hmm.
That the agreement can fail on that. If that waiver is not made,
Right.
You could invalidate it completely just on that.
Mm-hmm.
Yeah, you have to voluntarily and expressly waive the right to disclose, any right to disclosure.
Mm-hmm.
People will do that. They'll say like, we're not gonna list the assets.
Okay.
But you have to put in there like, we are specifically choosing not to do that.
Okay.
Like you have to say that in there and have that waiver in there. You have to have adequate knowledge of the property. So in the instance of the waiver, right? Like if you waive it, they know or should have known like what those assets were. So they take a look at that as well. And the independent legal counsel, like I said, is really like one of the biggest ones.
Mm-hmm.
And an argument you can make is that they executed the agreement involuntarily. That's not as common. Typically, it's subsection C of the statute that there are 4 factors that the court will typically look at.
Uh-huh.
And when they look at unconscionability, they look at the time it's being sought to be enforced.
Mm-hmm.
So you can have a situation where they enter into the prenup and it was completely fine. Mm-hmm. And then 30 years go by and all of a sudden now it's totally unconscionable. Mm-hmm. And it could be because a spouse had, career A and was making modest earnings and wife's like, all right, well, I'll waive off on alimony. It's not a big deal. And then husband's making millions 30 years down the line and nobody expected that to happen. Maybe it changed careers.
Right.
So that's a real big one, the unconscionability aspect.
Okay. And also whether there was informed waiver. So let's say the one party never mentioned that he had this portfolio of whatever, and doesn't tell the other side about it, and they don't know about it, then even though it's waived, the disclosure, they can still go back and invalidate it based on that.
Yeah. There has to be, if you're disclosing and you leave things off, that's a problem. In that case I was talking about with the post-nup with the pregnant wife, he also left off like a family trust that was worth hundreds of thousands of dollars.
Oh,
so I don't know how you forget about one of those, but he did.
The point is he didn't.
So that was one of the problems there is that, you're signing an agreement and you think you've got everything in front of you and you don't. Or if the person hides kind of like who they are, like that they come from this immense wealth and they're out there, in, like Bobos and ripped shirts and you think you're getting one thing and in reality it's completely different. And in that case, it's not a knowing involuntary waiver. You have no idea.
Exactly. All right. Now let's talk about, so we've gone through all the procedures that need to get to a prenuptial agreement, and we've gone over a lot of the benefits of of having one in the event of divorce or death, and when it can help. And also for those listeners who may be in a community property state, that can really make a difference as far as that goes. But let's talk about post-nuptial agreements. A couple comes to you, they're already married, and they want to talk to you about a post-nuptial agreement. When is having one of those advisable, and how can it help?
So first off, if the couple tried to come see me, I would definitely direct one of them to another attorney because
Okay.
you want to have that, you want to remove that appearance of impropriety.
Right.
So that's the first thing. So whichever spouse decided to stay with me, I would find out, what led to this.
Mm-hmm.
Is it everything's fine and they're just looking to do it now as opposed to doing it in advance? Or are there problems? And this is kind of the band-aid,
Mm-hmm.
right? Because sometimes it'll be used as leverage. Like I'll stay in the marriage, but I really I want this agreement. And so
Right.
one of the things that the court looks at is there consideration? Because you can't walk away from the marriage the same way you could with a prenup.
Mm-hmm.
So what are you getting for the agreement? If you're fixing your rights at that point in time,
Mm-hmm.
right, in the event of a divorce, what are you getting in exchange for an agreement that you don't have to make? You could just write it out, the marriage could fall apart, and then you go and do, your divorce litigation, how you would do it.
Mm-hmm.
So the courts want to see that there's some sort of consideration in that agreement.
Mm-hmm.
And that could be, I think, like a shifting of assets or a certain type of support. Like maybe somebody's going to agree to, give away more of the marital estate than they ordinarily would to get that.
Mm-hmm.
They'll look at the facts kind of surrounding it, but the reason they're so disfavored is because the spouse who wants to stay in the marriage is vulnerable, right? They're in this vulnerable position, and that makes it hard to really have these come through and not have kind of this air of unenforceability around them.
Mm-hmm. Now, you use the word consideration, and that's something we both learned in our first year of law school.
Yes.
But our listeners out there, consideration, it basically says that both sides have to get something out of it, right? It can't be so one-sided that that the other one is just taken advantage of. So there has to be some equity there, some balance where even though one party may be giving up one thing, they're getting an advantage somewhere else, right?
Yeah. Yeah. And another thing is that the reason the prenup's more advisable is because of that presumption of enforceability, right? Mm-hmm. The postnups kind of have this presumption of unenforceability with them, which makes it a harder hill to climb. And the court's not only going to look at the fairness of the agreement at the time it sought to be enforced, but they're going to look at the fairness of the agreement when it was actually executed. So right. There's kind of this dual review. What happened at the time it was signed versus what's happening at the time you're seeking to enforce it. And so that, to me, if somebody comes to me, like I'm really going to encourage them that this agreement on its face has to look like the other side's getting something out of it.
Right.
Because otherwise you go through all this money and then you not only have the divorce, but then you have a whole litigation on top of that as to whether the agreement you put into place to try to save yourself this headache is enforceable.
Right.
And so it's like a dual issue. So.
Right. So certainly, I mean, you can't, because what they don't want happening, I guess, is parties trying to do a bit of an end run around the divorce process by having, sort of agreeing to everything in a post-nuptial agreement.
Yeah, and the difference between like that and a marital settlement agreement is when you're doing a marital settlement agreement, marriage is done. Both parties usually agree that it's, irretrievably broken, like we are done, we're moving on. So there's not that vulnerability in the same way someone who's looking to prevent their spouse from leaving has in terms of leverage.
Mm-hmm.
So, and that's why, marital settlement agreements don't have that same presumption of unenforceability around them.
Right. Now, we've talked about post-nuptial agreements in the context of divorce. Is the analysis different or the enforceability different when dealing with death and the rights of the surviving spouse?
I would think that that's going to be subject to the same type of scrutiny, honestly,
Okay.
because it's the same thing. It's no different than waiving off of an asset or support. That if you're trying to get a spouse to waive their right of inheritance, to waive their right to the elective share, if you're doing those things,
Mhm.
I think there still has to be some consideration there. So I definitely don't think it's an estate planning tool the way
Okay.
it might be with a prenup, especially because of that heightened level of review.
Right. Okay. So overall, it's best to do it before rather than after. I
Yes,
think is
do it
the
before.
that's the
Plenty of time
lesson here.
before.
Yeah, it's kind of to a great extent, it's kind of too late once you get married, right? I mean, that's pretty much it.
Yeah, because even if you get somebody to sign it, the court's going to look at it under a microscope.
Yeah.
And they start looking at all the facts and circumstances surrounding when it's happening.
Mhm.
And, you know, those themselves could invalidate it. So it's really not the best thing to do.
So, I mean, the courts are going to look at it if it's challenged, right? But if both
Yes.
parties go into the divorce, they have a postnuptial agreement, and they both agree, "Yep, this is what we this is what we agreed to, and this is what we want."
Then it's fine.
Okay.
You can incorporate it in a final agreement. It's really only if somebody goes to challenge it. So if I met with somebody who had one, I would ask a lot of questions
Right.
about, what prompted this, what was going on at the time, did you get anything for this if it wasn't apparent on the face of the document,
Hmm.
to try to sort of suss out like what was going on when this happened.
Hmm. Okay. Well, we talked a little bit, and you mentioned several factors earlier, and I just wanted to circle back to make sure we cover completely where having a prenuptial agreement may well be able to simplify the divorce process and, in effect, save the parties a lot of money. Uh, do you find that, and obviously you mentioned the two exceptions of child custody and visitation and child support. Do you find that these prenuptial agreements do make subsequent divorces simpler, or do you end up in a fight over the terms of the prenuptial agreement?
So the cases that I've had involving the prenuptial agreement have not been challenged. I haven't had one yet where somebody tried to argue that it was not enforceable, and it did make it easier because when
Mm-hmm.
you got to that part of the dissolution, you just go, okay, what does the agreement say? The agreement says this. This is what they agreed to in terms of distribution. That's what I'm going to put in the marital settlement agreement. I acknowledge the prenup. I attach it as an exhibit, and those parts are done.
So
And
this,
you find out because I'll put it in the complaint. We want to seek to incorporate the prenup into the final judgment.
so the issue becomes more whether there's grounds for divorce rather than what happens as a result of the divorce. I mean,
Correct.
there might still be litigation over grounds and certainly on support and custody, right?
Absolutely. And the ground, ever since they came out with the irreconcilable differences statute in, I want to say 2007, even the grounds have become less contested
Mm-hmm.
because all you have to say is we had a breakdown of the marriage. It's lasted
Mm-hmm.
for 6 months or more, and it's irretrievably broken.
Yeah.
So that makes it easy, at least,
Okay.
because you can avoid litigation on that ground too. So then you're really only dealing with maybe issues of, custody, parenting time, and child support.
Mm-hmm. Does that, in your experience, result in a lot more litigation and therefore expense? Because that's nothing, as you mentioned, a prenuptial agreement is going to do nothing for you as far as those two issues. Do parties oftentimes end up spending a lot of money on a divorce fighting over those issues even when
Yes.
everything else is settled?
Yeah. I have had cases where that was the only issue and they were protracted and litigated and very expensive for that reason.
Okay.
People tend to dig in their heels, I think, a little bit more on the parenting time and support issues than they do on asset distribution issues.
Mhm. So you're taking a lot of issues off the table with a prenup, but it doesn't necessarily, at least in issues where the divorce involves children. I mean, you may have a
Yes,
childless, divorce where the two are just divorcing, then that's not going to come up. But once you add children into the mix, it's kind of difficult to predict whether that prenup is really going to save you that much money.
Yeah, and if it's a situation where it resolves like the issue of alimony,
Mhm.
then I think it can sometimes because that's another really big protracted issue that you end up fighting over. So if you can narrow at least the issues you're going to fight over,
Mhm.
there's an advantage to that.
So even if the prenuptial agreement involves uh, issues of alimony, that still has to be litigated. Is that another exception to what a prenup does?
No, if you deal with the issue of alimony in the prenup, if it's not contested, that issue's done.
Okay.
So if you have kids, what you're doing by doing the prenup is you're eliminating all of the other issues
Hmm.
except for the child custody issues and the
Hmm.
resultant support obligation.
Right.
So you're taking, like you have issues that are, maybe this big and you're narrowing them down maybe to two or three
Right.
rather than having to deal with the whole kit and caboodle.
Well, how many divorces end up involving alimony these days? Is it a significant portion or?
Yeah, I would say most of my cases have some sort of alimony component in them.
Mhm.
Yeah.
Well, again, me, the non-family lawyer, you hear about an obligation of support to maintain the other party in the lifestyle they have become accustomed. Uh, but I can see where you have one spouse, like you said, who they sacrificed their career for the other, and the other made a lot of money, and that wasn't something that was contemplated at the time of the prenup. And now you have a huge inequity as far as income. That one
Yep.
party's been out of the job market for a long time, and this other and the one with the money is making a lot more money than originally contemplated. So that is something that is easier to contest, would you say, in a prenup if that becomes an issue?
So you can either have the prenup, if the prenup is silent on the issue of alimony, you treat it just as you would in an ordinary divorce case.
Right.
If the prenup addresses alimony and the situation has changed, then you have to challenge the prenup itself to
Okay.
reopen that issue.
Okay. And that basically because of substantial change in circumstance after the marriage. Is
Yeah.
that, I mean,
Yeah,
is
that's
that
kind of
sort
the
of
argument.
the litmus test or the standard
Mhm.
that's used by the
Yeah, that
courts?
it's like so unconscionable. I've been out of the job market for 20 years. I've got, 8 kids. It's, I did everything for this guy. And now I'm stuck based on an agreement I made when I was like 23.
Right. Okay. All right. And I suspect post-nups aren't that helpful on this anyway, as I think you said before, as far as trying to save money unless the post-nup pretty much predetermines the divorce issues and both parties are still willing to go by it and they don't
Yeah,
challenge it.
absolutely.
So they can both be used as good tools,
Mhm.
financial tools, uh, depending upon the circumstances of the case, I guess, right?
Absolutely. Yeah.
Mm-hmm.
And I think people who are getting married really should be more open to the idea of the prenup because
Mm-hmm.
it really is just controlling your own destiny.
Mm-hmm.
And people get so exhausted of the divorce process.
Mm-hmm.
I don't blame them.
Mm-hmm.
And this is a tool to make that so much easier. God
Okay.
forbid that happens.
Really? All right. Well, I appreciate all your information on pre and post nuptial agreements, and certainly taught me a lot. I'm certainly the same for the listeners out there. Uh, and so your work colleagues here in Gloucester County, New Jersey, and your offices are in Woodbury, right?
Yes,
Okay. And this is what you do. And I mentioned in the intro that you're a certified matrimonial attorney.
I
How
am.
does that distinguish you in this area of practice from other attorneys who are not?
So to become a certified matrimonial law attorney, you have to file an application to just take the exam.
Mhm.
And they review like your entire career. They want to see that you've had X number of cases go to trial, X number of cases dealing with, motions, how many plenary hearings. So you have to do this entire application and lay all that out for the committee. And then you have to take a written exam.
Mhm.
So kind of like a mini bar exam. And once you pass that, then you are deemed to be certified. But only 2% of the attorneys in the state across all the practice areas are actually certified. So you can become certified in matrimonial, civil, criminal, And there's one more, and it's not that common, but
I
it's not
believe it's
relevant.
workers' comp.
Maybe it is workers' comp. It might be that.
Yeah.
It's only 2% of all the attorneys in the state across all four areas, especially. So
Okay.
it's a pretty small group
Mhm.
that gets qualified to take the test and then takes it and actually passes it. So
Mhm.
it's the Supreme Court saying that they've found that I have expertise in this area.
Okay. And if folks in southern New Jersey have issues, whether they want to do a prenuptial agreement or a postnuptial agreement, or they think their marriage is falling apart and they need your services, and really services outside of divorce. I mentioned adoption and paternity determinations, college contribution, that sort of thing. How can they reach out to you?
You can call our office at 856-251-0800, or you can find us online at smedleylawgroup.com.
Okay, great. Well, thanks for coming on the show, Allie, and thanks for educating all of us on these pre and post nuptial agreements. And we'll be monitoring social media to see how uh, Kelsey and Travis and
Definitely.
Taylor work things out,
Yes.
and we'll go from there. All right,
Thanks, Steve.
all right, bye bye.
All right.